Okay.
It's my one. I run issues when I get too busy. That's what it's. Trying to make my best, honestly.
Yep, you're on.
Ready when you are, Malcolm.
Yep, all set.
Okay. All set? Well, I say, good evening. Welcome to the July 8th meeting of the Zoning Board of Adjustment. We have, one application on the agenda tonight. So I guess we should just get right to it. First of all, have you guys had a look at the application?
Yes. Yes.
Yes.
So, does it look complete?
Yes.
Malcolm, you go to a point.
Yeah, I was gonna say, we need to appoint.
Yes, right, Mike, I need to appoint Mike as a voting member tonight, so we have 5 here. Thank you, Naomi. Okay, now we're ready to go. Do I hear a motion to accept?
I make a motion to accept application, case 07-2025 as complete.
I second.
Been moved and seconded. Any discussion? Okay, being no discussion, all those in favor?
Yes.
Yes. Yes.
Yes.
Any yes? 5-0. We're good to go.
Excellent. All right, good evening. My name is Matt Peterson with Keach Norsham Associate, here representing the variance in front of your board tonight. The owner and his attorney is with us also, and they will get up to give you a little presentation in a minute. Just to kind of give an overview of what we're looking at here, I'm not sure how many of you were around when this was first looked at, but about 2003, 2004, this was a 10-lot subdivision that, looking at the plans and everything that went into it, was probably took a little bit of time to get through the town here with the different easements and drainage and cisterns and everything else that I see here for the 10 lots. Since our client has picked this up here, he's been working with the town to try and see what makes the most amount of sense. Obviously, putting a road through just didn't seem to make as much sense from a cost standpoint right now from what we're looking at. It seems also that, you're making a connection between the two roads. It just seemed to be what he's proposed to move forward here seems to make a lot of sense, I think. And I think that's why we're in front of this board tonight. So with that, the first plan that you have kind of shows what was in 2003. You'll notice things out on like Bernard Hill Road. There was a drainage easement on the abutting property. I'm assuming that that was a detention pond or so for the town road that was going to be needed up in the corner there. You also had a site distance easement that was needed for that town road there. And then as you come down the property line a little bit more, there was a second drainage easement. Again, I'm assuming it was for grading and stuff like that on the abutting property. You can see from this plan here, the Eastman Way, that was the proposed, or is, I would say, the proposed right-of-way. This is actually a subdivision right now. Could go out there and do it until we consolidate everything that's here. So that's the right-of-way that shows through the property. If you turn to sheet 2, this is what we're proposing with this subdivision. Again, just to give you an overview for tonight, not everything here is in front of you for the variance, but we're proposing 2 homes off of Eastman Way, basically extending the right-of-way to where the existing pavement is out there today, creating the frontage for those 2 lots, and then leaving the 1 main lot for 1 house coming off of Bernard Hill Road. That is the reason we are here tonight. If you switch, the next sheet will show you basically the first sheet with the topographic information and a 4K area and a proposed road going to a spot located there. The last sheet is really the most important one there. That shows you the grading plan for proposed driveway. Again, we held the center line of that right-of-way. So at the time, that was a 24-foot road. Now it's proposed as a 12-foot driveway. We're approximately 700 feet in, and we need a variance to cross the buffer at that location, which apparently, looking at my regs and back in 2003 and 2004, because it was going to be a town road, did not need the variance. but as a driveway, it would need the variance. We believe this makes sense as one lot in this location here. Again, we've done a lot of work with the town, kind of piecing this together before we got in front of you guys here. So we're putting something forward that made sense. And really, that's all I've got. I know the attorney's going to go through the arguments and stuff like that, but if you have any questions on that, I can answer them.
I do have a question about
Yeah,
the,
go ahead.
I'm looking at the map, and I'm looking in the upper left-hand corner.
Which one are you looking
I'm sorry, page 3, and I'm seeing where the driveway crosses the area, why the easement is here. Your words were, it crosses the 25-foot buffer. I believe that's what I heard. And I think I do see that, but I also think I see a finger of the wetland itself reaching out. Just, yeah, I'm reading that correctly. So
Yes,
it crosses
yes.
the buffer and a few feet of the wetlands.
So if you go to the last sheet there, you can see that there's a buffer impact disturbance of about 1,000 square feet and a wetland disturbance of about 1,200. We haven't finished the wetland yet. It's going to be plus or minus 1,200. We got to work with DPW on walls and stuff like that to make sure the numbers are rip-rap on the outlines, stuff like that. But yes, there is a wetland impact and a buffer impact. We just don't need the variance for the wetland impact.
Interesting.
A quick confirmation, if I heard you correctly, the entry point off of Bernard Hill Road for this driveway is the exact same location as would have been the
We use the center line of this driveway was the center line of that roadway,
previously approved.
previously approved, yes.
Thank you.
Yep.
Covered my question. That's fine.
Perfect.
I saw that you're crossing the buffer, but you are actually going through the wetland, and you will be getting the permits you need for that.
Absolutely, yep. We're already in the process with our wetland scientists, looking at getting the pictures and the classifications.
One more question, if you'll indulge me, and this is for my education.
Yeah, absolutely.
You said that you need the variance to cross the buffer, but not the wetland itself. Is that because that approval comes from some RSA or planning board or something?
Your regulation allows the crossing of driveways, roadways with a wetland permit, if I read that correctly in the regulations.
The wetlands permit will come from DES, but
Right.
once obtained, your regulations allow it.
Excellent.
It's the buffer that is not accepted.
Okay.
Which is kind of interesting.
Yes.
It should,
That's interestingly written.
I think it came from the town of Bedford because they have the exact same variance I have to get for buffers. There's not many towns that I have to do it in.
And one more clarification, I know that we're focusing on lot 191.
Yep.
This is the 18-acre lot.
Yes.
There's two adjacent 10-acre lots.
Yes.
With Eastman Way not being pursued, just curious, what's the access point for the other two lots? Or
Well, if you take a look at sheet 3 of 3, they'll come off the end of Eastman Way. So currently, right now, you can see it says EOP in there. There's actually pavement into our site in a hammerhead. We're just going to make it in a formal right-of-way now around it so that we get the frontage
Thank you.
and clean it up.
And both driveways will come off of the
And both-
hammerhead.
Yes, and both driveways will come off the hammerhead.
Thank you.
Great. Any other questions? Anything to add?
Yeah, I just have a few things to go over in terms of the wetland, or the variance criteria as it applies to this application. But just to, finish the conversation on lot 191-7 and 191-8.
Just before you start, can you just say who you are and thank you?
My name's Jonathan Booton. I'm representing Brian Kelly for this variance application. But though the existing pavement and then what'll be, cleaned up and repaved as part of the turnaround, provides the 50-foot of frontage for a paved town road that is required under your regulations. So that's why we're not seeking any sort of exception or waiver for that access off of Eastman Way and the access off of Barnard Hill is obviously needed because of the buffer, as Mr. Peterson discussed. So there's 5 criteria for a variance. 2 of them are very closely related as to whether it's whether it's contrary to the public interest and whether it's consistent with the spirit of the ordinance. The test used most often on the public interest criteria is whether the variance would alter the essential character of the locality or pose a harm to public health, safety, or welfare. If that's the case, the doctrine says that the ZBA should deny a variance. We don't think that is the case here. We don't think that a single-family residence on an 18-acre lot is doing anything to alter the essential character of the rural neighborhood. We don't think there's any impact to public health, safety, or welfare. We'll discuss the wetlands impact in a bit and define how the plan minimizes it and accounts for it, because that is actually a little bit more related to the substantial justice prong. And then as far as whether it's consistent with the spirit of the ordinance, in the memo that I drafted, I listed a bunch of the purposes that your ordinance listed for the various requirements that it sets forth, and they include whether it would cause expense to the town from misuse or abuse of the wetlands, to encourage low-density use that's harmoniously, appropriately, and safe to use close to wetlands, provide flood protection, protect unique and unusual animal or natural areas, including wildlife and travelways, water supplies and existing aquifers. And then, there are no aquifers that'll be impacted by this crossing. There are no wildlife corridors that we're aware of, and they do have to look at this whenever they do any wetlands impact. It's, it is actually a significantly smaller impact to the buffer and the wetlands itself, because a driveway requires a 12-foot section with 2-foot shoulders, whereas a road is a 24-foot, and then with the associated slope easements, the impact would have gone far wider, closer to the property line, on the lower portion of the driveway as it crosses the wetlands. If you look on map 3, kind of that bottom corner would have been impacted, and then up near the road, that other drainage easement would have been, the property would have been impacted up there, causing removal of additional trees and things like that to create the proper slope and stormwater protection systems that would have been required. Here, it's significantly less that's required. We're taking half of the width and lower impact on each side of that width to support it adequately. Another prong is the diminution of property to the surrounding properties. Right now, there's a 10-lot subdivision in there. It'll be a 3-lot subdivision, which is, I think, would only enhance property values in the surrounding area, but it's certainly, there's no evidence that we can find that would diminish property values. Another is the substantial justice will be done. This prong is essentially a balancing test. Does the harm to the applicant outweigh the benefit to the town if the variance is denied, or on the, and the alternative is the benefit to the applicant outweighed by harm to the public that will be done if the variance is granted. Again, we don't really see any downside to the public. In fact, the town actually does not have the additional maintenance expense of Eastman Road because it's not going to be put in. There will be all private easements and stormwater protection and wetlands requirements put in instead of the public ones that would have been required under a town road. The way that it's designed, if you look at sheet 4, they've got culverts and slope easements or slope designs to minimize and protect against flooding, against other damage that would be caused by the impact to the wetlands, and allow the natural flow of water to continue. I think you did design it up to, what, a 50-year storm?
We'll have to look at the culverts and make sure that passes, probably even 100 year at this point.
Yeah.
Yes.
And that'll be handled at DES level, but either way, it's going to be designed to handle a significant water event and not cause, additional property damage. And the harm to the plaintiff is pretty obvious because he's got, a 38-acre parcel that, he's getting a new subdivision for to make it a 3-acre subdivision instead of a 10, and then he wouldn't be able to develop his property without the variance to access the property there. There really is no building envelope on the road side of the wetlands because the property is so narrow. There is a site easement up against the road which cuts into the buildable envelope as well. And the wetlands gets wider the further, as you go parallel to Barnard Hill Road. So that access at the lower portion of the lot is the narrowest portion of the wetlands we could cross. And I assume that's exactly why Eastman Way was designed there in the first place, but it makes the most sense to follow it. And some of those characteristics are directly related to the unnecessary hardship prong. So the first test under the new statute, which defines what is needed to demonstrate whether unnecessary hardship would be imposed if the variance were denied or if strict compliance with the ordinance was required, is what unique characteristics of the property set it apart from other properties of the area. And if you look at any of the plans, really, they show how narrow the lot gets as it approaches Barnard Hill Road. Other lots have much more frontage, have wider widths as they approach, and the wetlands crosses the lot in its entirety. So there is no access to the rear, probably, I don't know, it's probably 12 out of the 18 acres that are on the backside of that wetlands. There's no way to get to them without crossing, that buffer, which is why the variance is needed. And as I mentioned, the site easement is also impacts the building envelope, that would be any closer to the road with the wetlands. So those are the unique characteristics. Then you look at whether there's any substantial relationship between the letter of the ordinance and whether or not that would cause an unnecessary hardship. If you don't find it directly that way, you look as if there's a substantial relationship between it, then is the use reasonable based on what the variance you would be giving? And it's a single-family lot. It's not designed, this is not a stepped process where there's going to be a future subdivision, which will require additional approvals anyway and couldn't be done without, the town weighing in again. But it's really, this is, at this point, what they consider the end game is a 3-lot, single-family residence structure, creating a nice, small, large lot subdivision for people to establish homesteads. So I think that imposing strict compliance with the terms of the regulation and not allowing the wetlands buffer impact would result in an unnecessary hardship, in that, the use of the property is reasonable, given what's designed. Are there any questions on either the design or any of the variance criteria that we talked about?
Questions?
None?
I'd just like to make a statement, basically, that what has been stated has covered all of the prongs that we are going to be addressing. You did well. Normally, we go by the prongs, and we have you read those. No reason for you to go through and do it again. I think we're fine with, I'm fine with the way it was stated.
Yes.
I was going
know if anybody else
to
has.
close with that. I'm going to say,
Yeah.
we have a lot of times, people will paraphrase it, or they'll do something, they say, see attached, and then they go, different directions. So I was on guard when you started. Then I noticed you were following the 5 points, and that's pretty much the format of our application. So you covered everything.
Okay, great.
Just to kind of, for the future.
Yep, appreciate it.
Stick to that. Any other? Okay.
Abutters?
Yeah,
What's that?
Approving, disapproving?
Hey, I know. Are there any disapproving of butters?
I am the abutter. I do have some questions.
Pardon?
I am I'm the lower abutter.
Are you disapproving or approving?
I'd like to ask questions.
Okay, can you go on record as
I'm new to this.
curious? You're a curious
Curious.
butter. Okay, come on up and ask your questions then. Just state your name for the record.
Sure, Keith Pike. I live at 176 Barnard Hill Road, the property below. And I've been there since 2005.
All right.
So I met Brian today for the first time. And so I did get the abutter notice on June 20th. And so my questions or my concerns are really, I am below, and so there is a water grade issue, right? So Barnard Hill, I've lived there since '05. We've survived Mother's Day floods. Barnard Hill was unpassable for about a week at the middle of the road where the shooting range is. So water is a real problem on that road. And I know that the gentleman that does Public Works has had to fix the road on the sides of the roads over the years too. So my questions are really around the wetland and the requirements, because I did hear conversation around a 24-inch culvert. I just want to be clear, and I understand what those requirements are. I think that's the minimum requirement. I'd like to understand, because I think we heard 50-year, 100-year. I mean, we've survived some serious water challenges in New Hampshire, and so that's my concern, because I am below grade, and that water could impact that creek does flow behind our property and comes down behind it. We see it. So I kind of want to understand what that requirement is and what those studies are. And then really, was there an actual engineered drainage plan that shows the flow of water and what that impact is if we have a 100-year storm? So that's what I kind of would understand. And then I am concerned, because if there is an event, right, a major storm like we saw in Alstead, or we're seeing in Texas right now, right? So what's the impact to my property? Because if the water does come down, it could damage my property. I could lose property value, right? I mean, that could be a real impact, and we've seen some serious cases across the country and in New Hampshire. So I just want to understand that and clarify that, what that impact would be and how that looks. I'm very appreciative. I'd rather have 3 neighbors than 10. I get that, and I think that, that's a good thing that the town's looking at that. But I just want to understand that impact to me, if there is a severe storm, which we've seen, what that would happen, what would happen. Because that water could create damage, and it could create property damage to me and I have horses and I have animals, so I just want to make sure that we're not doing damage.
Great, thank you. Would you guys like to address that question?
Yeah, and I want to preface this by saying, while I'm going to say why it shouldn't bear into the consideration on this variance, it's only because when the planning board approves the subdivision, those are exactly the kind of things that'll be discussed and conditions that can be put into the plan. And it is also directly related to the DES wetlands permit that is going to be required to do anything and build into those culverts. So that's another opportunity, I think, where your concerns can be better addressed and relayed. Because the town ordinance doesn't have a regulation or allows the driveway crossing if the permit is obtained from the state, the impact to the wetland itself is not really subject to, or within the purview of this variance application today. And that's the only reason I'm saying, I don't think we can address it here, but I do think there's 2 other forums that is a very good place that this can be addressed and concerns brought into the final plan that's executed. And, both of those decisions would be appealable if you're unhappy with what happened as well. So while I certainly appreciate the concerns and we, share them, we're certainly not intending to put a design in place that's going to make things worse instead of better. But we really can't do it here based on what is in the zoning ordinance.
Thank you.
So to add to Attorney, and I apologize if I say it wrong, Booton?
You got it?
Okay. What he said, he's spot on with DES being very entrenched, no pun intended, in what takes place with wetlands especially. And then with our planning board and, even the road agent may have some concerns as well that need to be addressed. So to your point, yes, you do have concerns. This isn't the place for them to be discussed. It really will be at the planning board or with DES. And I'm sure that the landowner would be more than amenable to have you present when they're discussing these things so that your concerns are voiced to them. So,
If I can add just a sentence or 2 to that, one way to think of this is just sort of one hurdle they get past, and we say, assuming that, DES and everything agrees with you and your math checks out and everything, then it's okay by us. But that's the checkpoint that really digs into the 50-year versus 100-year and everything. And this is more, we've got a line in our zoning code, you can never, ever, ever cross a wetland buffer. And we're saying, well, can they cross 700 square feet? So that's the topic here and not the engineering and other aspects.
Right.
I'll just add one more comment. I appreciate that Mr. Markarian let us know that you could weigh in. We are required to send you the abutter notice for the DES application and for the subdivision plan. So you will absolutely have details of what we're proposing and the opportunity then to weigh in at both state and local approvals.
That's it, well, you got lots of other levels and steps to go through, and you'll have your chance to have your concerns addressed. But here is not the place. Okay, are there any other abutters approving or disapproving? Public at large, other boards, committees? Being none, no rebuttal? Okay. I close this, so we can discuss it.
I make a motion
Go.
to accept prong one.
Move.
Second?
Did I hear a second? Okay. Moved and seconded to accept prong one as presented. Any discussion?
Going down a few cases, under Gray v. Cedel, 1999, would the variance cause a benefit? Is irrelevant. Would it cause a harm? There's been no evidence that it would cause a harm. Under Chester Rod and Gun Club versus Town of Chester, 2005, would it alter the essential character of the neighborhood? No one has suggested it would. No one has suggested it would threaten health, safety, or the general welfare of the public. And under a 1999 municipal law update from NHMA, if the applicant makes even a conclusory statement that it would not cause a harm, that's enough unless someone contradicts, so.
Great. Any other discussion? Being none, all those in favor?
Yes.
Yes.
Yes?
Yes.
And a yes from me, that's 5-0 on prong one. Do I hear a motion for prong two?
So moved?
Seconded?
Move to accept prong one, seconded, okay. Moved and seconded, any discussion?
Prong two.
Prong two, excuse me. The
Discussion
heat.
is, what is the spirit of the objective? And it is to conserve as much as possible wetlands. And applicant in this case had a proposal that took that in mind. He didn't want to bulldoze down through the middle. Further, by going with this route as opposed to the initial route, in the 12-foot driveway as opposed to the 25-foot road, that lowers the impact on the specific wetland, because either the road or the driveway would cross here. So this seems to be well thought out to minimize impacts, which is very much in the spirit of the ordinance.
Agreed. Any other discussion? Being none, all those in favor?
Yes.
Yes.
Yes?
Yes.
And a yes. Prong two passes 5-0. Do I hear a motion to accept prong three?
So moved?
Seconded?
Moved and seconded, excuse me, to accept prong three. Is there any discussion?
There is a clear benefit to the individual putting in a home, and no harm to the public has been mentioned. So substantial justice, in my opinion, is done.
I agree.
I agree as well.
Agree.
Yes. Agreed.
Any further discussion? Being none, all those in favor?
Yes.
Yep.
Yes.
Yes?
Yes.
Get a yes from you?
Yes.
Yeah, and a yes from me. Prong three passes 5-0. Do I hear a motion to accept prong four?
So moved?
Second?
And moved and seconded. Any discussion?
I think, the fact that they are being conscious and going from 10 to 3 homes, though it won't necessarily impact negatively on the home costs and prices there, it shows a due diligence that they've done to reduce the impact to the properties around them.
Okay, any other discussion?
Prong one is not the same as prong four, but there's still something interesting in prong one, which is if the applicant makes even a conclusory statement that it would not cause a harm, that's enough unless someone objects. And, physical harm is a type of harm, so I think we can drag that over to prong four. The applicant has made that assertion. No one has made a contrary assertion.
Exactly, yeah. Anything else? No more discussion, being none. All those in favor?
Yes.
Yes.
Yes?
Yes.
And a yes from me. Prong four passes 5-0. Do I hear a motion to accept prong five in its entirety?
So moved?
Seconded.
Moved and seconded to accept prong five in its entirety. Is there any discussion?
Uniqueness, it's not perfectly unique in that we've seen cases like this every 2 or 3 months where someone wants to cross the narrowest part, but it certainly is something that distinguishes this property from 9 out of 10 properties. And, one thing we often touch on is the uniqueness caused by the applicant's personal circumstances? I've got 6 kids, or I want all 3 of my boats to have a parking spot, or, something like that. And there have been Supreme Court cases saying that personal circumstances are not relevant, but land uniqueness or circumstances are, and this is a textbook case of that.
Plus, it's a reasonable use.
Yeah. And it has the least amount of impact
Yeah.
from the entire property, as far as where they're going. So, I mean, they've
I agree.
done their research.
Is there any further discussion? Being none, all those in favor?
Yes.
Yes.
Yes?
Yes.
Yes, prong 5 passes in its entirety. You have your variance. Good luck.
Do you have any use for your large-scale handouts back, or? Just getting recycled by me.
I wouldn't mind taking one with
Great. There's a memento.
Extra budget, but thank you for the eye exercise going through it.
Anybody got another spare they don't care to have?
Yeah, you can have mine.
Yeah, here you go.
Perfect. Thank you guys.
Got another one if you want it.
That was gonna be recycled.
What's that?
That's for the recycling.
Okay.
Thanks, guys. Yep.
Now we have a set of minutes to look at. Everybody had a chance to look at that? Corrections, revisions?
Yeah. Well, question is that in several spots, it just says Bolton instead of Ms. Bolton. Does that matter or not? You know, if not, then.
Technically, yes. Practically, no.
Yeah. So, it goes either way as far as that goes. You know, we could have them all inserted as Ms. And then, on page 7, line 329, Mr. McKenzie to speak to whether or not, it says tress, but it should be trees, had been cut down.
Trees, line 29. Trees
329.
instead of tress.
Yep,
Catch.
329. So, that was what I had. Naomi, you okay with being referred to as just Bolton?
One and only, the official.
Any other revisions? Typos? Okay. Do I hear a motion to accept the minutes as amended?
I so move.
Second it?
Moved and seconded to accept the minutes for June 3rd, 25. Any discussion? All those in favor?
Yes.
Yes.
Yes?
Yes.
And a yes. Minutes are done. Do I hear another motion? Is there any other business before the board?
There is,
You do.
we do. We have the subject of a request for rehearing by Mr. Eldon Towns. Came to us in our emails. If you hadn't seen it, I can
Okay,
share
I
the
got,
copy with it.
I thought you said this wasn't an issue now. I didn't get this email.
You should have.
Did you guys get this
It
email?
didn't go in your package.
I didn't check.
Didn't
My
go in the
bad.
package. It was in
Okay.
our emails.
Where's the
So-
zoning? Is this, okay.
That's the third page to that.
May I skim the first page while you're on the
Yeah.
second? Thank you.
This
Our
is,
first and second are together.
Where's, okay. Can I have that second page back?
The second or the?
Yeah.
the
Does
second
anybody,
one?
do you have another printout of this, Naomi?
The original.
All right, so this has been received by the Board of Selectmen. Mm-hmm. Is it scheduled to be heard?
Naomi, do we need to,
That's a good point. Was
how
this
about
on the,
part? Should we,
oh,
is that?
it's not.
we need to
It's,
talk about that?
if we discuss it, it would be other business. It's not on the agenda.
So we would take this as a motion to rehear. That's where we're at.
So a procedural question, if it's not on the agenda, can we address that tonight?
It doesn't necessarily need to be on the agenda, it should be on the agenda, but this is whether there are anybody here or not, this is a closed deliberation, and what we do is we just look at it and check and see if it's in order, and if it has merit. In other words, gives us a chance to identify any mistakes we might have made, and if we see mistakes that we made, then we would have to grant the motion. If we can't see any mistakes, we don't have a problem with what we did, then we wouldn't grant the motion for rehearing. So there's no real discussion from out there at all. We have to be public with it, but,
So I think there are two halves to my question, and you certainly addressed one half, which is, it's a public meeting, it's being recorded, it's
Yeah.
going to go on the agenda, so I'm not concerned on that aspect. And I think you might be right in the answer, I just want to dig in a little bit. There is no need to put it on the agenda 7 days or in advance or anything like that, because no testimony is allowed, because it's just our
Exactly.
business. Great, okay. I've raised the issue and I've gotten the answer, thank you.
what we need to look at here is, this application is, in their motion, they need to specifically, and I see specifically here, list their issues, and then we have to look at them and address them accordingly, whether we agree or disagree, or whether we see it or we don't agree, and then make our decision. The only other issue that we would have here is that I was a little bit caught off guard. I was primed, but I didn't get the email, and you guys didn't get the email, so we're a little bit off on our heels on this.
Using their email?
Pardon?
Is everyone using their email?
The town email account?
That's where it goes. It goes to zoning board at, and everybody should get funneled in.
Right.
Paying for email addresses.
It's a minor issue, really. I'm not, like I said, depending on the depth
We
of...
got away from personal emails.
Pardon?
We got away from personal emails.
Yeah. Depending on the depth of the motion, whether or not we want to move this to next month, or we look at, if we're not comfortable looking at it.
So, I agree that it did come through email. I haven't looked at it before just now, and there are some allegations about people not being allowed a chance to rebut. That is something that I would like to actually verify by looking at the video. So I am not prepared right now to say I believe that objection is correct or that I believe it's incorrect. I just don't know.
I would honestly tell you, I don't think we failed to give everybody a chance to speak. I think that was the one where you moved to shut it down and move on, and I didn't recognize that motion. We were in it right up to our necks, and I think we gave everybody a chance to speak. And the one thing I want to stress is that I think that was a mistake on my part as far as allowing everybody to come up and voice the same concern. I don't have to do that. We don't have to do that.
And I think to your point, though, to your concern, Travis, generally, in all the proceedings that we've been in, right, you have your applicant that presents, you have your abutters, whether approving or disapproving, and then all the other entities that can come up and present. And then the applicant has the opportunity to rebut any of those comments. We don't generally have a rebuttal
second round.
to a rebuttal.
Right.
So I think the opportunity was given for them to voice their concerns, their opinions, as Malcolm said, maybe to nausea. But the rebuttal comes from the applicant, not from those that are presenting opposing arguments.
That's a good point, and I think you're correct.
I would,
If I could
I
add
don't
to
want to
Travis.
go on too much, but basically, there are two concerns on this from what I pick up. One, procedural error, and he's made a list, all right? And I've looked at them, and I don't think we made any procedural errors that were material. Everybody had a chance to speak, everybody had their say, more than everybody, it seemed like, okay? But the only issue with the motion that I would question is the lack of new evidence. How do you guys feel about that? That, to me, if we're gonna look for any kind of merit in this motion, that's where I'd be looking. I don't think there is.
I mean, Malcolm, just to pause a moment, just curious about just Kurt's point, is there any grounds? Is there any basis for there to be this request by someone other than the applicant? Because procedurally, if that's not the case, then we don't have to talk about any of it.
So as far as,
I don't mean don't have to, I'm not trying to
for
avoid it, just,
is
it appropriate?
It doesn't have to be just the applicant based on the RSAs. It could be an abutter, it can be any entity that
Okay,
that
just to make
puts
sure.
in a request for a rehearing. In this case, what we're talking about as far as rebuttals go, it was during the meeting itself that we're being accused of not allowing rebuttals from those that were opposed to the applicant's comments. And generally, we don't have rebuttals to a rebuttal. It doesn't work that way. It's, you know, you had your chance to present against, they did. The applicant has a chance to refute, rebut the comments that are made, which was done as well. There, as far as that goes, I don't see that we did anything procedurally incorrect. As far as new evidence, I don't think we were wrong with that either, from the standpoint of when we were first presented the case, we were under the guise that the person that was presenting as the applicant was doing so for the possible, the person that was going to buy the property, not the property owner. So when it was brought to our attention that there was that the property owner hadn't given that permission to that gentleman, that's when we opened up the rehearing and allowing the case to be reheard. So I don't think we did anything wrong there either.
I don't think it needs to be held to the standard of new
I'm not gonna
evidence.
say, I don't think we did anything wrong. Based on everything that we have, we did nothing wrong. So it's not a matter of think, it's a matter of knowing what we have in front of us, what the RSA's say, what our zoning ordinances say. We did what we were supposed to do by the letter of the law as it's presented to us.
I tend to agree, and I just want to add one thing. Usually when somebody places a motion for rehearing, there's a very specific point they want to make or need to make. And these right here don't seem very specific at all. There's no, pardon my expression, but smoking gun here. There's nothing here that, like Kirk said, we didn't do anything procedurally wrong, or we didn't make, if we made mistakes, they weren't material. And as far as new evidence, I think it was, there was plenty of stuff presented.
So I'll weigh in on that. I first agree with Malcolm and Kirk about you don't get a rebuttal to a rebuttal. That has never been the norm. I've never seen anything in an RSA saying it has to be done that way, et cetera. I would say that the first paragraph immediately after specifically, if I can rephrase a little bit, a concern that I think is legitimate is not, there was no new evidence, because it's as if the initial hearing never happened. You know, that's what the redo was. So the only thing that matters was this. So the word new or old is irrelevant. We should just look at that hearing. In that hearing, the applicant has the burden of persuasion, and in that hearing, I basically did not see that there was any evidence. And so I think that this board ruled on many of the prongs without properly applying the standard of burden of persuasion.
But that's outside of this request.
Well, I'm arguing,
Because it seems like we're almost rehearing
Well-
that variance request.
I would say it is inside this, because I think that the paragraph right after specifically with sort of a somewhat charitable reading of that, you know, if I say, you know, hey, he didn't need to insert the word new there, and he, you know, wasn't arguing this before the New Hampshire Supreme Court, you know, I think that this is a layman's arguing of a valid point, which is, I don't think that there was evidence presented that even approached the burden of persuasion. And I know I'm mostly disagreeing with you.
I think it seems like you just argued both ends of the same point.
Okay.
So initially, you said that there's not, because of the first hearing, not having an authorized presenter, that coming in June, there's no reference to new or old.
Right, right.
That's- Okay.
And so therefore, I'm saying the
so-
word new sort of doesn't belong there.
Right.
And so strike the
So-
word new out.
So what I would clarify on that is generally, so we had the initial hearing, right? And what he's talking, and the way I read it and the way I've heard it before is that we had it brought to us as an appeal to reopen it by the actual landowner, right? And to Mr. Town's point, he's saying that at that point, when we reopened it, we had no new evidence that would warrant us reopening the case, which
I
I
follow the point
disagree
you're
from the
making. Yeah.
standpoint of, once the applicant came before us as the landowner versus a potential buyer, and it wasn't even the potential buyer, it was someone that represented the potential buyer. They didn't represent the landowner. So that was new evidence that allowed us to act on reopening the case. I think that's what he's talking about, not a
Right.
matter of,
If he were, so I,
Just hold on for a second. We can't really get into what we think they're talking about.
yeah.
And that's where I'm coming from with this motion to rehear. I don't think it's specific enough. I don't think there's a lot of material here that really is relevant or raises to the level of merit. I don't think it has any merit. They have a course they can follow as far as the Superior Court, which is their right. But I do not think that this motion was presented very well. It's incomplete, basically. So on those grounds, I would say we shouldn't be granting a motion for rehearing. We need more than this, and I don't think they've really presented enough.
So, since some of you haven't seen your email, so this was also part of an email that we got this morning from the town administrator regarding this same case. So I will pass what I printed it out, I'll pass it on to you guys to read. Whether it has it really doesn't necessarily have a bearing on our
Oh,
decision
yeah,
here,
okay.
but it should be known that some things are going on involving this case. that-
Really, I appreciate that you presented it, Kirk, but I don't think this is relevant.
Okay.
I'll let you guys look at it, but I don't think it is relevant. It's a totally separate situation. It's acted in a totally different way.
Yeah, I agree. There's other
Is
avenues.
there any further discussion on the merit of the motion? Being none, I would like to hear a motion to grant.
Yep, in the affirmative. I move that we grant the applicant a rehearing.
Is there a second for that?
Second.
Been moved and seconded to grant the motion for a hearing. Is there any discussion? I think we had a lot of
We had it,
discussion
yeah.
already, but I want to be procedurally
Yep.
correct. And I will just leave it with this. I don't think this raises up to the level of merit. I don't think it has enough merit to grant a rehearing.
So my question would be is, on the motion, is it the applicant that's getting the rehearing, or is it the actual abutter, the opposing abutter that's getting the rehearing?
That's a good question.
Because it's the opposing
So
abutter.
maybe we shouldn't phrase it as we grant them, should it be perhaps I motion that we have a rehearing? So-
No. He,
Okay.
as an abutter, he has a right to move,
Okay,
to move for a rehearing.
So the
As I
phrasing of the
understand it,
motion
he has
on
the
the...
right to make that motion.
Okay.
And he presents his motion, and he's got to present the motion with some
Right.
specific
But
detail.
my motion on the floor is well phrased, you believe?
Yes.
Great.
It's phrased well enough. It
Great.
doesn't need
Okay.
to be.
So that's the motion. I think
Yeah.
it was seconded, so I think we're...
Moved and seconded, so I want to be clear about this. I've had my say. Any other discussion?
No.
I've had my
Just want
say.
to make sure that we understand what,
Yep.
the motion is in the affirmative, so,
Should we rehear?
okay.
So a yes
All
means
those in
a
favor of
do-over.
granting the
Yeah,
motion?
yeah, yes means doing over, redoing the,
Correct.
Yes.
Are you sure you know what you're voting for?
No, no, yeah.
So yes means do the whole thing over
No.
again. Okay.
okay.
The
No,
motion is to, yeah, okay.
no.
Yes.
No.
And a no. Okay, the motion for rehearing was not granted 4-0. 4-1, excuse me. 4-1. Get all that, Naomi?
The note taker will do it, not me.
I motion to adjourn.
Seconded.
Moved and seconded, we adjourned. Any discussion?
Nope.
All those in favor?
Yes.
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 Any yes for me? 5-0, the motion